Let me just start off by saying that as an attorney who represents a number of school districts throughout the state of New Jersey, I spend days at seminars on this issue in and of itself. A single issue, we can spend an entire day with a room full of lawyers and discuss the HIB legislation and still come out with unanswered questions. So it's going to be very difficult for me to give you a short, concise, do it by the numbers analysis and review of the legislation and its application, because it's still in its infancy. This law has only been in effect as currently constituted for 2 years. It started in the 11-12 school year, so this is now the third school year in which this legislation has been enacted. There are regulations that are still not yet promulgated by the Commissioner of Education to further explain the legislative intent of the statute. And certainly it doesn't really change that much, something that not only school districts but everyone always knew was a concern. And obviously the legislation was enacted because of data that was collected about bullying and harassment that was being conducted on school premises, not only at public schools, but certainly even in secondary schools and private schools, colleges, etc. So that's what was the initiative for this kind of legislation. But I want to make sure that there's two things that we understand throughout this entire discussion. And the first is, as I said, it's not that much different than what was on the books before what came to the law. Obviously, we have affirmative action laws that try to prevent hostile work environments, not just from employees, but hostile educational environments for students. So that affirmative action complaint procedure that had always been in effect throughout school districts was always there and continues to be there as a mechanism to avoid hostile work environment situations, sexual harassment situations, again, not just from an employment or an employee standpoint, but also from a student's standpoint. The second thing I wanted to make sure that everybody understands, and this is the mantra, that whenever we talk about this, I want you to always have it in the back of your head, because I might say something and it's not going to make any sense, and how could this possibly be the resolution to a certain situation? But the mantra is always in the back of your mind that we've always had a code of conduct that says what's right and what's wrong. And if you do something that's wrong, you will be penalized or punished or disciplined as a student in the district. That was here before anyone ever put the 3 letters together to make a HIB. And it will continue to be there now and after that legislation was put into place. And you could have a violation of the code of conduct, but not have a HIB violation. But therefore the consequences, that even if it was found to be a HIB, might be exactly the same. The consequences, the discipline, the remediation, the counseling, the behavior modifications, all those kinds of things that we're looking to do as educators and as people who want to teach the students right from wrong and teach them a lesson as to how to do better in the future. All of those mechanisms were here before, and they're still here. It's just we've added another layer in order to ensure that we have the right answers and the right procedures to address those concerns. That's really what we're talking about from a global standpoint. Again, with regard to trying to limit this as much as possible from a time standpoint, I think the best way to proceed with this would be to go through basically, and I did already more or less, the legislation about the time it's been in effect. There are very few, if any, cases that have been litigated to a level of the Superior Court or the Appellate Division or the Supreme Court of New Jersey under this legislation as currently enacted. So we're not going to be able to talk too much about the law as a judge has interpreted it, because again, as I told you, it's only 2 years old under the way it currently is, under its current enactment. So I'm not going to be able to cite you cases or give you a good perspective as to precedent, as to how a judge is going to review some of these findings. So from the legislative standpoint, I think we've really covered that. What I also want to cover, though, is the most important elements of this HIB legislation deals with, goes to the definitions themselves, because we throw those words around, HIB, and harassment, intimidation, bullying, but there are specific definitions, as any statute should have, in telling you what that means, so that we are able to interpret it, not just from a legal perspective, but from the school district's perspective, from the administration and the board, to figure out whether it applies or it doesn't apply. So I will go through with you rather quickly, and you can see why you can spend days talking about this when I go through the statute with you with regard to the actual definitions. The third part of it that I want to go through real quickly is the procedure, because there are procedure with regard to reporting, there's procedures with regard to the investigation, there are timelines with regard to those investigations, there's an appeal process, and all of those I think we can cover rather quickly on a rather easy timeline. And the last are the practical applications and the unanswered questions that you will obviously see are here when I give you a quick review of those first few items that I want to go through with you. So, with regard to the legislations, to go back, there were these laws in effect, these HIB laws that were in effect back to 2002, but they weren't in the format that we see them today. And you got and from 2002 until 2011, they were just out there without any regulations to speak of, other than telling you that you should adhere to the statute, which really doesn't help anyone. And the governor and the legislature also were trying to get together to develop a better HIB statute that would be more workable. And they did that, as I said, effective for the 11-12 school year. You have to also keep in mind that when the legislation was adopted and put into place, without regulations, because regulations are there to help us interpret the law and to apply the law and to fill in the gaps, because as thorough as legislation is, it's never, because lawyers can make things, I guess, say a lot of different things in a lot of different ways, and so can private citizens when they take a look at it. You need these regulations to give the intent. We don't have those. So I'm going to stick with the definitions for you. And I think the best definition is the easiest one that we are going to have to look at, but I'm going to read it very slow the first time, and then we're going to go back and break it down into segments. Because they actually define, by the way, the statute reference is 18A 37-14, are where these definitions for the current harassment, intimidation, and bullying statutes are located. 18A, as most of you know, 18A is the statute that school laws falls under. Now there's three parts of this definition that's important. The first part to define is who can a victim be? And there's no question that the victims are students in these cases. Not like an affirmative action where I was talking about victims could be employees, or victims could be co-workers between other people. When we're dealing with the HIB, the victim is a student. An employee could not be subject to a violation of HIB under this statute. Only the students could be victims of HIB under this statute. The second definition, obviously, is who can the perpetrators be? Who are the potential bad guys, or girls, or students in this particular legislation? And really, it could be just about anybody. It could be another student. It could be a staff member. It could be another employee in the district. It could be a contractor to the district. It could be the board attorney. But again, it has to be to the student. So anyone who comes in contact with the students, on school grounds, at school activities, through the internet to one of our students, those people could be the potential perpetrators of this statute. And the third definition is the incident itself, the definition of what a harassment, intimidation, and bullying actually is. And let me go through it with you. one time and then we're going to go back and break it up. That's what lawyers do. Harassment, I'm reading straight from the statute. Harassment, intimidation, or bullying means any gesture, any written, verbal, or physical act, or any electronic communication, whether it be a single incident or a series of incidents, that is reasonably perceived as being motivated either by any actual or perceived characteristic, such as are the characteristics: race, color, religion, ancestry, national origin, gender, sexual orientation, gender identity and expression, or a mental, physical, or sensory disability, or, and this is the one we're going to talk about at length about, or by any other distinguishing characteristic. All the other ones I think we can figure out, but we'll go back and make sure that there's no uncertainty as to those. But the interesting one, and the one that's causing the most misconception, and the one that's causing the most misinterpretation as to whether there's a HIB or not, as to did it occur to the victim based upon the victim's other distinguishing characteristic. By the way, that definition still is not done yet, so I'm going to keep reading. Any other distinguishing characteristic that takes place on school property, at any school-sponsored function, on a school bus, or off school grounds, as provided in another statute for discipline, that substantially disrupts or interferes with the orderly operation of the school or the rights of other students. That's the definition. Now, that's a lot of stuff to deal with to determine whether there's a HIB or not a HIB. The two easy ones we took care of. Students could be the only victims, and just about anybody who deals with our students could be a perpetrator. So that's clear. Now the question is, was it a HIB or wasn't it a HIB? And that's when we have to go back to this definition, because there are certainly events that happen on a day-to-day basis in schools, depending upon the age of the students, depending upon the circumstances that led up to an incident, that will make the district reach a determination, a conclusion, that either the HIB existed or it didn't exist, because it really comes down to the intent of the perpetrator and the reasonable impression upon the victim. And those two things sometimes aren't the same, because the perpetrator may have meant to do something for a specific reason, but the victim didn't perceive it that way. And that's why if we go back, all these words that I just was using in describing it come from the statute itself. Go back. Gestures, written or verbal physical acts, pretty easy. Any electronic communication, we all are starting to find out more and more what those mean, and every day they change as to how they can be done. Whether it be a single incident or a series of incidents, so again, based on the severity of a single incident, it could take just one incident for it to happen, or in the common definition that we all know about harassing. Harassing usually we think is something that happens over and over again, but that could be the series of incidents that we were, minor incidents that are a series would be equivalent to a single serious incident. And again, the key to the entire definition is as follows. That's reasonably perceived as being motivated. Now, reasonably perceived is by the victim, reasonably, which means we get a whole room full of people, and if 99 of those people wouldn't have perceived it to be a problem, but one person does, it may not necessarily, notice I didn't say it isn't, it may not necessarily be a HIB just because the victim perceived it to be, because if a reasonable person wouldn't have perceived it to be that way, it shouldn't meet that definition. Now,